This is David Parker with the Law Office of David Parker and another entry on my video blog. Medicaid eligibility and asset transfers. As long as assets are available under state law, they can count for purposes of Medicaid eligibility, no matter how long the assets were transferred to another. The federal government, perhaps understandably, takes a dim view of trying to game the system when it comes to eligibility for Medicaid. A recent court case highlights this fact, which can be important for decisions regarding elder care and New York asset protection. The cases arose in Wisconsin, where an applicant had transferred funds to her children 17 years before applying for Medicaid. The case in question is Hedlund versus Wisconsin Department of Health Services. Lucille Hedlund transferred all of her assets except for her checking account to her children in 1991. The same day that she transferred the funds, her children put it all into an irrevocable trust with their mother as the beneficiary. Medicaid ruled that this was reason to infer that Mrs. Hedlund had directed her children to do this, and that the funds were available to her under state law. On that basis, she was denied coverage under the Medicaid program 17 years after the trust was created, as she entered a nursing home in 2008, and the court upheld the denial. Medicare provides limited coverage or none for long-term care, and so Mrs. Hedlund was stuck with the necessity of using up her carefully protected assets before federal aid would cover her. The cost of medical care and of long-term care in elderhood are important considerations for New York estate planning, and as this example shows, the rules underlying federal programs can be tricky. Before you or a loved one attempt to do something that you think may work for purposes of qualifying for federal Medicaid assistance and avoiding asset depletion, it's wise to seek competent legal advice. I'm David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney.